We're live.
Thank you, Kayla.
You're welcome.
Good afternoon, colleagues. It's Thursday, March 31st. We're for another brief hearing session. We have to be back in, I believe, at 2:30, so we will not be taking long. Please keep your questions at a minimum. We'll have time to discuss these during our actual voting sessions. We're going to jump to Senator Smith, since he's the only one on. House Bill 449 to start.
Mr. Chairman, members of the committee, hi, my name is Luke Pinton. I'm Senator Smith's Chief of Staff. He apologizes he can't make it. He is on the floor at the moment. So I'm here to present on his behalf Senate Bill 449 on unlawful employment practices remedies. The committee is probably familiar with this bill. It's identical to Senate Bill 911 from the 2021 session, which passed Economic Matters Committee on sine die, but stalled on the floor. The bill increases the caps on the amount of compensatory and punitive damages that may be awarded to a plaintiff in cases of unlawful employment practices. It's necessary because the caps have not been adjusted since 2007. And so the bill makes updates to the caps based on inflation since 2007, and then adds a 5% increase each year so that the statute doesn't have to be continuously updated. And then the bill also increases from 2 to 3 years the amount of back pay that may be awarded in such a case. And it was changed from 2 to 3 years to match the federal employment discrimination statute. And with that, happy to try to answer any questions. I see that Jeffrey Simpson from the Metropolitan Washington Employment Lawyers Association is also around. I don't know if he's signed up for this bill or not.
He signed up for this bill. I was going to call him when you're done. All right. Lily, do you have a question?
Could you define what is unlawful practice in this bill?
I believe it's defined elsewhere in the statute. I don't have it right in front of me. I apologize.
That's fine. We can also, if you think this would be questions for the attorney, that would be fine too, but I don't want to put you on the spot. So we do have Jeffrey Simpson. Is he on?
Yes, I am.
Okay, so Lil, if you don't mind, can we go ahead and send this to Mr. Simpson? Thank you. Go ahead.
So I'm here on behalf, I'm Jeffrey Simpson on behalf of the Metropolitan Washington Employment Lawyers Association. Thank you for having me. An unlawful employment practice would be discrimination on the basis of race, sex, disability, marital status, genetic information. And that would mean if somebody's hired, failed to hire, failed to promote, fired, or suffers harassment as a result of any of those protected characteristics, or else is retaliated against. So that's the universe of issues that we're talking about. And this bill is necessary because the statutory cap hasn't kept up with inflation. We're still talking $2,006 for when the Maryland bill was passed, and really that's based on the federal statute, which was passed in 1991. And I represent employees who have been fired, and we actually have a checklist of symptoms. And very often, people who are fired, experience severe depression. They have nightmares for months and weeks, or months and years. Can't sleep, get withdrawn from society. And when jurors hear that and want to make them whole, they are limited by the cap about what can ultimately be awarded, even if a jury thinks that some greater amount is necessary. A person who has suffered unlawful conduct can't recover all that a jury would think that they deserve, and that's why we think that the cap should be increased, and it should be increased to keep up with inflation.
Okay, I know we're gonna have a few questions I would like to ask. So, I've been fired from quite a few jobs. Are you saying these people have nightmares, depression, and all that from being fired?
Yes.
Ooh,
and so
okay.
yeah, so it is a very common thing. I do this for a living, and people come to my office, and sometimes they're barely functional. And it's not just the case of being
from being fired from a job, they're barely functional.
Yes.
All right, so let me ask you another question. That's the track I'm worried that we're going on. So what's the current cap?
There's a a number of different caps based on the size of the employer. So the lowest cap is $50,000 for 15 to 100 employees, $100,000 for 100 to 200 employees.
Someone
200
goes up to, what's the maximum?
the maximum is 300,000.
Okay, and does that include attorney's fees, trouble damages, anything else like that? What, in a successful suit, what all can the employer suffer?
So the employer, so that would be, so this cap would be in addition to back pay and attorney's fees.
Wow. So, and there really is no limit on attorney's fees, is there?
Oh, no, there definitely are limits on attorney's fees.
There are
It has to
caps
be,
on attorney's fees?
there's not a specific cap, but it has to be a reasonable attorney's fees as determined by a judge.
Right. So $1,000 an hour is not unreasonable depending on the experience. I say this because I'm a trial attorney as well. Depending on the experience of the trial attorney, $1,000 an hour is not unreasonable if you have the experience, correct?
I would very much like you to make that argument in cases where I've been successful.
Okay.
So yeah, $1,000 an hour in Maryland would be extremely unusual.
Okay.
So
To make it clear that they're not only, and you're trying to increase this cap from 50,000 to what?
So for the smallest employers, it'd be 50,000 to 65,000.
And then, and every year go up an additional $5,000?
It would be 5%.
Okay, I apologize. 5% every year, just from now on,
Yeah, just to keep up with inflation. Yes.
regardless of what the CPI in any of that is.
So the way that the bill is written, it is 5%. But if there is a proposed amendment to track CPI, I would support that as well.
Okay. Lily, did you want to ask this gentleman a question? Because I'm sorry I interrupted you before.
No, actually, I have a new question now.
Yes,
I'm just
please.
wondering, look, I want to understand why the amount awarded is tied to employment size.
So that is a determination that was made long ago, and I don't know the rationale underlying that. I think it is most likely based on the ability of smaller employees to pay awards versus anything else. So I think that there was an expectation that a smaller employer would not be able to afford damages at the same level.
I'm just wondering if it should be based on the actual damage assessed instead of your ability to pay, which is the size of employees you hire. I'm just trying to understand the connection between the amount awarded, a cap, and the size of employees you have.
So, and I don't have a specific answer for that. That was a decision that was made when the bill was originally passed in 2006, and if my memory serves, and it was based on the federal model where they adopted that approach. And I assume it was based on the belief that a smaller employer would not be able to pay as large a damages amount.
Thank you.
Delegate Watson?
Thank you, Mr. Chair. Would you mind giving us an example or two briefly of a situation where the employer might be charged or found responsible for these fees?
For these fees, for the compensatory damages?
Yes.
So it would be cases where there's an employer and one of their employees commits a sexual assault in the workplace. And, as a result of the sexual assault or persistent sexual harassment over the course of years, the employee develops severe depression, anxiety. There have been cases of post-traumatic stress disorder, and so on and so forth. And when just like in any lawsuit, the charge to the jury is to make the employee whole. And the jury would determine that, in some cases, $400,000, $500,000 would be an appropriate amount because there is no precise measure of, kind of damages for, various conduct and harm suffered. It's, kind of the result of it.
Okay, so let me just stop you a second. So an employer has a manager, for example, who harasses a female employee over a period of time, and it ends badly and she's fired. She could then come back and not only get her, so if the jury found in her favor, she could get her medical expenses paid. In addition, she would get this, the jury could award her up to this sum of money.
Yes, that is, well, the jury wouldn't know about the cap.
Okay.
If the jury could award, more than the cap, and then the award would be reduced by the judge.
Okay, and in a lot of cases, but not all, there is something called employment practices liability insurance that would also provide reimbursement to the employer for this. But I would just say, I've seen these cases over and over again in a particular industry that I work in, and it doesn't seem unreasonable to me what you're asking.
Thank you.
Seeing no other questions, thank you very much, sir. We'll move on to our next hearing. I believe, was Senator Hershey online? I saw him look like he jumped on.
I did just jump on. Are you there?
Oh, yes, you're very close. Okay.
Great.
Well, since you're here, Senator, we will go to you next. Senate Bill 985, and please, Senator, be aware that we have to be back on the floor in a very short time.
I just jumped off the floor myself. We're still on it, but I wanted to be able to present this. So thank you very much for fitting me in very quickly,
Yes,
Mr.
sir.
Very quickly, this is a bill that came to us from the Department of Labor. As everybody recognizes, there's been an awful lot of unemployment insurance fraud during the pandemic period. This was also a recommendation from the unemployment insurance report that we received. And it simply does two things that we did. One, it gives the secretary some additional responsibilities as far as how she will, or how the secretary will enact these types of penalties, what we'll go forward with in looking for fraud. This brings this legislation in compliance with what 6 other states have done. And then second, it increases the fines for unemployment insurance. And there is a woeful violation that has a imprisonment penalty that we increase from 90 days to 1 year, and also a monetary penalty that went from 1,000 to 2,300. And then there's penalties also that are, if you are in the chain of command and dealing with the process in a sense, any type of internal violations, we increase those penalties from 1,000 to 2,300. That, Mr. Chairman, I would appreciate a favorable report and here to ask or respond to any questions.
Senator, was this bill cross-filed?
No, it was not. As I said, it came in late from the Department of Labor based on the final report that we got on unemployment insurance.
Thank you very much. Delegate Charkoudian, you have a question.
Yeah, thank you, Mr. Chair. Thank you, Senator. I guess my understanding of most of the fraud that we saw was sort of these international crime rings that were stealing identity, and sort of caught up in that. And my concern is, I'm trying to read this. I see that there were a lot of changes that were made in the Senate. So I'm catching up on, I saw the original bill. I thought it was cross-filed actually, but I saw the original bill anyways. And my concern about focusing on penalties, I have a couple, but the biggest one is like, we're not catching the folks who are doing this. There's like this misconception out there that the fraud, it was even said on the House floor that the fraud was, like a regular, Joe Marylander taking unemployment when they shouldn't be. And really that's not the vast majority of this. And so I'm just trying to figure out if this is the right response to the fraud that we saw, given that the fraud that we saw was really, more focused on more of these like international groups. I'd like to stop what we saw happening. I'm just concerned that I don't know if this is the right
Senator, we don't
response. I
want
just
you
want to
to-
respond to that.
Yeah, so if I could.
You have time? You have time, Steve?
Yeah, I can do it real quickly.
Okay.
Mr. Chairman, real quickly, I do apologize. It was cross-filed, but the House bill is still in rules over there, so that's why it had not come to us yet. But Delegate Charkoudian, you're very right. Most of the big fraud came from these international types of things, but there was still enough local fraud going on within the state that they felt that this would disincentivize that type as well too. So it doesn't necessarily address the international stuff because that's handled on the federal level. But these are things that could be handled within the state of Maryland and hopefully disincentivize that.
Okay, I'll follow up also then with the department then for some data. Thank you.
Okay.
Thank you very much. And Senator, you're the only one testifying, so thank you for stepping out. We can move on now, bud. Have a good day.
Thank you guys very much. Thank you, Mr. Chairman.
We'll go back to Senator Smith, 450. Are there any other senators that have signed in first? Seeing none, we'll go back to House Bill 450.
Mr. Chairman, thank you. Luke Pinton here again for Senator Will Smith. I'll be super quick on this one. Senate Bill 450, harassment and sexual harassment, changing the definition of sexual harassment for employment discrimination purposes. It's identical to, it's cross-filed with Delegate Queen's 1393, which has not yet been heard in ECM due to a late introduction, but it's identical to Senate Bill 834 from the 2021 session, which passed out of ECM on sine die and also stalled on the House floor before the end of session. And I'm happy to go further with a brief introduction, but I saw that, I noticed that you wanted to move quickly, and I saw Lisa Jordan from MCASA popped on the line. I'm not sure if she's signed up or not.
She is. We can go ahead and get to the supporters for the bill. Is Michelle Siri here?
Yes, sir. Thank you, Mr. Chair. I'm right here. Good afternoon, Mr. Chair, members of the committee. Michelle Siri, I'm the Executive Director of the Women's Law Center of Maryland, and I will be very, very brief. I want to thank Senator Smith, of course, for his leadership on this, and also Delegate Queen for her support and leadership on this bill. And mostly, I want to thank this committee for passing this bill out unanimously last session. It is a very straightforward piece of legislation. It does some logistical things, moves some things around, but mostly it conforms the definition of sexual harassment and harassment so that they align with what they should be. And it removes an overly burdensome standard, which is the severe pervasive standard. And that is, if you look through the testimony, it has been just overly burdensome throughout the years. I would defer to the folks at National Women's Law Center and with Lisa Jordan with their testimony regarding the specific examples, but it really just shows that our laws needed to be updated. And I'm just here really to answer any questions and just to remind folks that this does not in any way create a civility standard. We still, folks must still prove that they have been harassed, that the harassment was unwelcome, that it was offensive, and that they, experienced an unreasonably abusive or hostile work environment, and that they were part of a protected class. So none of that changes. This law, again, just removes that severe and pervasive standard that has been kind of just misinterpreted through the court throughout the times. And with that said, I know you all are trying to get out of here, so I want to be respectful of time, and I'm just happy to answer any questions.
And thank you very much. Moving on to Andrea Johnson, excuse me.
Thank you, Chair and committee members. Andrea Johnson with the National Women's Law Center and a resident of Silver Spring, Maryland. We strongly support SB 450 and its rejection of the severe pervasive standard, which some courts have interpreted in really harmful and outdated ways, such that cases involving conduct most people would find egregious harassment are being thrown out and not given a full and fair hearing. Just one example, and there are many more in our testimony, is a worker repeatedly making sexual comments towards another worker over a year and suggesting she be spanked. The court just threw that case out because it didn't meet the severe pervasive standard. This bill simply makes sure that Maryland's law is able to work as it was intended and capture bad behavior that no one should condone. And it's important to note that the severe pervasive standard has been particularly harmful for women of color because under the standard, courts parse apart and isolate and really minimize the intertwined sex and race aspects of harassing conduct instead of viewing it in the totality. So this bill is seeking to make sure that this law, again, operates as it should be to really protect against harassment for all women, all people, and women of color in particular. And we're seeing more and more states and cities rejecting the standard. Montgomery County in 2020, New York in 2019, California in 2018, and New York City actually rejected it back in 2016. So it's time to see Maryland join this movement. We've seen Colorado, Vermont, DC, and other jurisdictions this session working on similar legislation. And it's important to note that the language in this bill is not as expansive as what we saw in New York and California. It's more conservative language that follows more closely the federal law definition, but again, rectifying some of the problems we've seen come up over the years. Happy to answer questions.
Thank you very much, ma'am. Now hearing from Lisa Jordan.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're also here in strong support of Senate Bill 450. This is my first appearance in front of the Economic Matters Committee this session, so I did want to just say it is a pleasure and honor to be here under the new leadership. This is exactly the same bill that was passed out last year, no changes in the same form, so we thank you for that. We urge a favorable report again. At its heart, this bill just fixes bad case law and replaces it with a modern and reasonable definition of sexual harassment. It is bipartisan. It includes language that was developed by Chair Smith and amendments that were contributed by Senator Cassidy. As my colleague said, it's not about civility or politeness. It directs the court to look at the totality of the circumstances. And remember, that's everybody involved, not just the person alleging the harassment, but that's everyone involved. It makes it very clear that the conduct not be severe or pervasive. And really at its heart, it's saying that a little bit of harassment is not okay. It directs the courts to look at whether the conduct unreasonably creates a working environment that a reasonable person would perceive to be abusive or hostile. And really, as Maryland is facing such enormous workforce challenges, this is a needed change because it reassures employees and potential employees that sexual harassment is not part of the job. So we urge a favorable report on Senate Bill 450.
Thank you very much. I believe you have Jeffrey Simpson on this one again.
Yes, Chairman Wilson. I will cede my time because I cannot say it any better than my predecessors have said it, and I don't want to delay the committee's work unnecessarily. Thank you.
Thank you very much, sir. I appreciate your accommodating our schedule. Seeing no questions, we will move on to the next bill. Senator Smith, House Bill 451.
Thank you very much, Mr. Chairman. Luke Pinton here again on behalf of Senator Smith. Senate Bill 451, which is the tolling of the statute of limitations for unlawful employment practices. To bring a civil action alleging an unlawful employment practice, a complainant has to first file a charge with the administrative processes like the Maryland Commission on Civil Rights, wait 180 days, and then ultimately the has to be within the 2-year statute of limitations. Senate Bill 451 establishes that 2-year statute of limitations is tolled while the administrative charge is pending, so that a complainant doesn't lose out because of maybe a lengthy administrative process. And I just will note that this bill mirrors for unlawful employment practices the same tolling scheme that exists for unlawful housing practices elsewhere in the state government article.
Okay. Mr. Simpson on this
Yes.
bill as well.
Yes, thank you. So just to echo Mr. Pinton, this is really just a legislative fix so people aren't caught unawares of the process. If an individual employee files with the Maryland Commission on Civil Rights, that charge, they have 300 days to file that charge, and then they have to file in court within 2 years under current law. That means that there's just over a year for the Maryland Commission to do its job or not do its job, and the employee has to be aware that the statute isn't tolled. They very often pro se employees, and I am representing an employee in Maryland right now who had her charge pending at the Montgomery County Commission for 6 years. She totally lost out on all of her state employment law claims. And she had to bring her case in federal court because she had no idea that those claims would be lost. And so it really is just rationalizing the system so that the same process is applied to a person's federal claims and state claims, and so that a person isn't caught unaware and have their rights lost because they didn't understand the process.
Okay, seeing no questions, that concludes this hearing as well. Thank you very much, sir. I believe we now have a representative from Senator Simonaire. Are there any other senators online as of yet? Seeing none, do we have a representative from Senator Simonaire's office?
Yes, sir.
Okay, we're presenting House Bill 499. Go ahead and start whenever you're ready.
Thank you. Kara Contino here on behalf of Senator Simonaire to present Senate Bill 499. This bill would set term limits for the Board of Licensed Commissioners in Anne Arundel County to be 8 years. And it also creates a commercial bingo alcohol license. Our local county council recently authorized this, but we were told we needed it in state law. So we've added that in, and it is an emergency bill to allow that bingo license to go in immediately. That's basically the bill, and I would ask for your favorable report.
Could you explain what the emergency would have been? Or do you know?
It applies to the bingo license only. There's a local business in the district that has been authorized by the county. They are allowed to do sports wagering, and now they need a state alcohol license. So this emergency bill would have allowed that to go into effect and allow them to get their license immediately.
Okay. Delegate Ernst, I see your hand is up.
Quick, is there delegation support on this, or is it just Senator Simonaire?
I do know the Senate delegation supported it. I have not heard about the House. It did have a hearing, but I haven't heard about a letter yet. I can check with them though.
We would definitely need a letter from the House in order to.
Absolutely.
Mr. Chairman.
Yes.
I know that the House delegation will be hearing or voting on the bill tomorrow.
Okay, if only we had the chair of the delegation in our committee who let us know something. Thank you, I appreciate it. Let me know the outcome. I guess we have one witness, which is Randy Clements.
Yes, Mr. Chairman and committee, thank you for your time. I'll be very brief. I started working at Bingo World 43 years ago, and back then we had alcohol. In 1984, our business closed down for remodeling, and in 87, we reopened, and the bar was closed. So somewhere between 1984 and 87, Anne Arundel County Council put a prohibition on alcohol in the commercial bingo halls. Last year, the legislature graciously awarded us the right to offer sports wagering. Thank you very much. This year, we have since been approved by the Maryland State Lottery and the SWORC Committee to offer sports wagering. We know that alcohol, we would be very responsible with it, would just add to our entertainment experience and allow us to enhance and expand our base of employees. Anne Arundel County, as the Senator's office stated, unanimously approved us and rescinded the prohibition. It just, again, this gives us the opportunity to offer alcohol in our sports wagering area, increasing revenue for us and tax for the state and the county. And again, the state approval is needed, and we are asking for emergency consideration so that when we open our sports wagering area this summer, we would be able to offer alcohol. We intend to open by June 1st. Thank you for your time.
Okay, thank you very much. Seeing no questions, I believe that completes the hearing in this matter. We now have, do we have a representative from Senator Jackson's office or Senator Patterson?
Clay Jackson for Senator Patterson.
Yes, sir.
Are you ready for me, sir?
We're going to go ahead and with Senate Bill 926.
Yes, sir. Thank you. Thank you, Mr. Chair, Vice Chair, members of the Economic Matters Committee. I'm here, Clay Jackson for Senator Patterson and for Senate Bill 926. Senate Bill 926 specifically requires the Maryland Apprenticeship and Training Council and consultants to the council to clarify the code to include representation by individuals who are Black and Latino. Additionally, the bill establishes a workforce development program under Employ Prince George that trains at least 2,000 youth and adult in career technical training program. The program takes effect and is funded from years 2024 to 2026. Finally, the bill establishes a 2030 commission this year on the apprenticeships in Maryland and makes recommendations for enhancing the program for greater usage and ending the employment gap in Maryland. The commission expires in 2024 with the specific goals of reaching 80,000 apprentices by 2030. And that is Senate Bill 926. I believe someone may be in from Senator Rosa Pep's office to also testify, but I'm not sure.
Is there someone here from Senator Rosa Pep's office? Seeing none, how about Mr. William Taylor?
Yes, I'm here.
Please go ahead, sir.
Good afternoon, ladies and gentlemen, and members of the Finance Committee. My name is William Taylor. I'm the past chair of the Maryland State Apprenticeship Council, where I served for 14 years. I served under 3 governors. My purpose here today is to support Senate Bill 0926, which will include representatives by.
I'm sorry, Mr. Taylor, but your camera isn't on, so we can't see you.
The camera's not on?
Nope.
So start video.
Yes. You will have to in order for us to spotlight you. There you go.
Okay. In addition, consultants to the council should include representatives by Black, Latino, females, and individuals with disabilities to ensure that the Maryland Apprenticeship Council has diversity in gender and race in the sponsored program. We have developed a deep and abiding commitment to ensure there's balanced representation in employment opportunities. I'm an advocate for opportunities that will support diversity in the workplace and allow all individuals to become productive and contributing members of our community. I applaud the focus of Senate Bill 0926 to include diversity on the Maryland Apprenticeship and Training. The council should look like people that serve and needs a representative of all eligible workers. Additionally, a more diverse council will help and increase the diversity of apprentices. I understand that it's a shortage of skilled workers in a number of the trade professions. A number of communities have untrained workers who can fill these vacancies of an apprenticeship. A more diverse apprenticeship council will help fill the need of employers and unemployed workforce. The addition of female, Black, Latinos, and the disabled and other minorities on the council will help improve workforce development and working conditions within the state. I respectfully ask that you take the necessary action to ensure that the bill passes. We cannot afford to lose sight of the diversity at this critical junction. I ask that you take the necessary action to ensure that the Maryland Apprenticeship and Training Council include representatives of Black, Latino, female, and person with disability. Also, consultants to the council should be represented by Black, Latino, female, individual with disability. Thank you for the opportunity to serve this committee, and hopefully I would like to get a favorable report. Thank you so much.
Thank you very much, sir. I know before we have questions, but if you can wait one moment, we do have Senator Rosa Pep give his brief dissertation. Senator, if you're still
Thank you very, very much. I apologize calling you from my phone from the Senate lounge. I appreciate you making time for me. Obviously, I'm very supportive of this bill. Senator Patterson is the chief sponsor. He and I worked together on the amendment related to Apprenticeship 2030. This is basically designed to do 2 things. One is to meet the goals of the Kirwan Commission that by 2031, at least 45% of our high school kids will have had a work experience and hopefully an apprenticeship before they graduate from high school. To do that, we've got to scale up the number of apprenticeships. We got to do it in non-traditional fields as well as traditional fields. So we're talking about IT, we're talking about healthcare, we're talking about public safety. Secondly, as everybody knows, we have a skill shortage in Maryland in many areas as well that we need to deal with for businesses and for the economy. So what the Apprenticeship 2030 provision does is set up a commission to work for a year and a half, broad representation, business, labor, legislators, state departments, to come up with a plan to allocate the $25 million that the governor and the speaker and the president and the budget committees agreed to put in the budget for the coming year or coming years to be able to do startup costs to expand apprenticeships. Right now, we've got about 11,000 apprentices in Maryland. To get to where we need for Kirwan, the Blueprint Project, as well as to meet the needs of the employers, we need to get to 80,000, go from 11 to 80,000 by 2030. And the design is to have this commission come up with that plan. Happy to answer questions.
Thank you. I see one from Delegate Crosby. Mr. Vice Chair.
Thank you, Mr. Chair. Just quickly, I noticed that first off, I just want to commend Senator Rosa Pep as well as Senator Patterson for bringing the bill. I did notice though the fiscal note, and I just want to, has that been agreed upon, or have you worked with B&T and appropriations on that? Because it's several $1 million.
Yes, it's $1 million a year. It's specifically for workforce program in Prince George's. That's Senator Patterson's initiative, and it is in the budget.
Okay, thank you so much.
Delegate Chi.
Thank you, Mr. Chair, and thank you, Senator, for bringing this great bill to us. I wholeheartedly support anything we can do to enhance and expand apprenticeship opportunities, especially among our youth. I do have a question related to the diversity because I repeatedly heard comments related to Black and Brown and African-American Latino communities, which is commendable, but where are the Asians? I just wonder if that community was also being considered in terms of outreach and representation, because it is significant minority. And we, even have 10 legislators that represent that community. So I'm very curious about that, Senator. Thank you.
That is the basis of the original bill that Senator Patterson introduced. And I don't want to speak for Senator Patterson, but I think we should talk offline about that with Senator Patterson.
Thank you.
Okay, we have one question, last question from Chris Valderrama. Delegate Valderrama, please.
Thank you, Mr. Chair, and thank you, Senator Roosevelt. You and I had a conversation about this. Delegate, she basically asked the premise of my question. My question would be for his representative, if he could answer on his behalf. Is that CJ here?
I am here, thank you.
Yes, would the senator be amenable to a friendly amendment regarding the Asian community? Because this is a conversation I had with Senator Roosevelt when he reached out to me. And as he said to Delegate Chi, I offered that to him, but since you're representing, would that be something that he would be amenable to? I mean, I could ask him also as well, but since you're here.
Absolutely, Delegate.
He would be amenable.
Yes.
Okay,
great.
Thank you.
Seeing no other questions, I believe that ends this bill hearing. We have one last bill hearing, colleagues.
Thank you.
Thank you. Is there a representative from Senator Jackson's office? Okay, seeing none, because this is a Charles County bill, I'll just go ahead and cover it. I'm not sure how the policy goes, but I'll just briefly.
I'm sorry, Chairman Wilson.
I'm sorry, you there? Yeah. Mr. Lanier, are you there?
Yes, I'm going to present the bill. I apologize for that.
Okay. Go ahead, sir. Senate Bill 965.
Okay. Thank you, Chairman Wilson, Vice Chair, members of the committee. For the record, I'm Sharon Lanier, Chief of Staff of Delegate Deborah Davis, House Chair of the Charles County Delegation. I'm sitting in behalf of Senator Jackson. Senate Bill 965 authorizes in Charles County a person to have direct or indirect interest in up to 2 Class B licenses in any combination. Those include hotels, restaurant bars, and direct on sale beer, wine, and liquor stores. And the small business effect, which should be minimal, but potentially meaningful for small businesses to obtain licenses, additional licenses under the bill. We request a favorable report. Thank you, Chair Wilson.
Thank you. Seeing no questions, it concludes that hearing, and that concludes our bill hearings for the day. Colleagues, just keep your ears open as to the next part of the schedule. And I do believe we will be voting on Monday, but I'm not sure what tomorrow is going to bring us because we don't know what the floor is going to be. I just asked that everybody be there on time as the speaker asked. Thank you guys very much. I'll see everybody back on the floor.
Thank you.